Good afternoon and welcome. Today's webinar is part of our ongoing Learn at Lunch series put on by the Oklahoma Cooperative Extension Service with support from the Farm Service Agency. Today, Dr. Shannon Ferrell will cover lease agreements for farmers and ranchers in this final webinar of 2017. If you have questions, please type them out in the chat box in the lower right corner. Additional farm management resources may be found on our eFarm management site located at the address in the chat box. Dr. Farrell, I'll hand it over to you now.
All right, good afternoon, everyone. Thank you guys for joining us today. We'll try to make this one pretty short and sweet. We're going to go over some of the basics of putting together an agricultural lease agreement. And, prevalently in Oklahoma and lots of other states as well, many of these leases are handshake deals. And yes, a handshake can be a contract, except when we're talking about interest in real property. When it's an interest in real property, it really needs to be in writing, in most cases, to be legally effective. And there's just a lot of value in the actual process of discussing what the written lease should contain. Not so much that we necessarily are worried about the outcome of that process, but really just sitting down between landlord and tenant, talking through what the lease is going to involve, what the landlord and tenant will and won't do. That whole conversation really solves a lot of problems before they even become problems, because it makes the landlord and tenant conscious of what their rights and responsibilities are going to be under that lease. So today we're kind of running through a top 10 of issues that you need to consider when you're actually writing out your lease. And as Brent mentioned, there's lots of good resources out there. In addition, a couple of websites that are out there that are the result of some collaborative efforts between OSU and some other departments as well is the aglandlease.info website, and then, of course, Ag Lease 101, both of which have some materials that have been worked on by OSU personnel and personnel across other states as well. And a lot of the topics we're going to talk about today are going to be addressed in more detail in there. So we're going to take a kind of high-level flyover, but know that if you have any more information, need any more information about any of these topics, you can go to those websites and to the eFarm management website that Brent's put there in the chat box for you, so you can dig into those things in a little bit more detail. All right, we're sitting down to write this lease between landlord and tenant. One of the most basic things to include is the actual legal names of the people involved. And that might seem like it's a no-brainer, but you'd be surprised how many people overlook that. So when we're talking about legal names, I mean who actually holds legal title to this property. The legal title might be held by an individual. It might be held by married couples in the form of a joint tenancy. It might be held by a trust, partnership, LLC, corporation. The list goes on and on. But we need to find the actual deed to that land and figure out who actually has legal title to it. And then also, we need to understand who's going to be the landlord, because it may be the landlord operating as a trustee of a trust. It may be the landlord operating in their capacity of holding that land in an LLC. But let's understand who's actually owning the land and who is going to actually be leasing the land. So those proper legal names matter. If there's an LLC or any other form of entity involved, we need to make sure that we understand who's going to be legally obligated by this lease, because really at the end of the day, the lease needs to show that the lessor or the landlord has the legal capacity to give someone permission to use this land for a period of time. And we also need to make sure that we're binding the right tenant to that lease. When we're talking about names, in addition to talking about the proper legal names of the landlord and tenant, we also need the proper legal name of the farm. And the proper legal name of the farm is not the old Smith Place or the Jones 80 or any of that stuff, because nobody remembers who those people are and they have no idea who you're referring to or what you're referring to. So in the lease, it's okay if you want to use that commonly used name, but that needs to be accompanied by the actual proper legal description of the land. That's just meant to give legal effect to the lease, but also it's an important notification to the tenant to say, look, the amount of permission I'm giving you to this land is limited to the description of the land that's made part of the lease. So I don't have the power to grant you anything outside of what I'm describing here. You don't have any lease authority over anything outside of the land described here. It's defining the borders of what you're actually giving permission to use. Now, as part of that legal description, something that you might also want to include is if you want to specify any points of access. In other words, if you'd prefer that the tenant access the property from location A versus location B, C, or D, you can specify that in the lease. And also, it's important to remember what a lease is. And without making you guys all go to an entire semester of property law, when we give someone a lease, basically we're conveying to them for a limited period of time all of the rights that we have in the property that we own. So if you're the landlord and you give a lease to someone, unless you've specifically withheld interests or rights from them, they are basically stepping into your shoes, and the only difference is that they're doing it for a limited period of time. So, for example, if I am giving someone a lease, I've not withheld to myself the right to enter that property. Basically, I've given them the exclusive right to possess that property, which means I don't even have a right to be there. And you're thinking to yourself, well, Ferrell, that doesn't make much sense. I need to have the right to enter the property, inspect it, make sure the tenant isn't tearing things up. And you're right, but you have to explicitly reserve that right to enter the property. That's not something that's implied in a land lease in Oklahoma. Now, other states may interpret that a little bit differently, and indeed Oklahoma interprets it a little bit differently when we're talking about residential property versus unoccupied property. But for the sake of an agricultural land lease, if we are talking about Oklahoma, you need to reserve in the lease explicitly the right for the landlord to enter the property and to inspect it. Okay, we've defined who's involved in the lease, we've defined where the lease is. Now we need to define when the lease starts and ends. And there are lots of different flavors and variety of leases that are all defined basically by how long the lease is going to last. But the two big ones that we're going to be concerned with today is what's called a tenancy for years. You might also hear that referred to as a tenancy for a term versus a periodic tenancy. Here's the difference. A tenancy for years, aka a tenancy for term, has a defined start point and a defined end point. For example, this lease shall run from July 1st, 2018 to June 30th, 2019. That would be a tenancy for years. It has a defined start and end point. A periodic tenancy might read, this lease shall commence on July 1st, 2018 and shall run from year to year thereafter. Now, when we do that, we've created what we call a periodic tenancy. And the major difference is, in a tenancy for years, the lease itself provides notice to the tenant when the lease will end. So the tenant knows, I better not do anything on this land that I can't wrap up by this end date because I know this lease is going to end. And with a tenancy for years, the tenant cannot assume that the lease is going to be renewed. With a periodic tenancy, the lease is going to automatically renew unless one of the parties, either the landlord or the tenant, provides notice that they want the lease to end. Now again, the tenant shouldn't assume the lease is going to be renewed, but until they receive notice, the lease is to be renewed. That gets a little bit confusing, so let's talk about a situation that we see happen a lot in Oklahoma. Many times in Oklahoma, we see a periodic lease that starts and ends with a calendar year as our renewal dates. So the lease starts on January 1st, and it's just assumed that we want to keep on going unless we receive some notification. Okay, in Oklahoma, if we have a year-to-year periodic tenancy, so our renewal period is 1 year, Oklahoma statutes say that you have to have 3 months notice to terminate that periodic tenancy. Other states handle that differently, and some states handle that specifically to the crop that may be raised on there. For example, the Kansas statutes and the Iowa statutes have terms that say, all right, if it's a crop lease of land for corn or for wheat, here are the assumed renewal date notice periods. But we don't have that in Oklahoma. It's just 3 months, all right? So if our lease is going to renew in December 31st, if we don't do anything, let's go back to November 30th, October 31st, September 30th. Now, by September 30th in Oklahoma, if we're leasing winter wheat stocker ground, what have we probably already done by September 30th? Now, in lots of cases, we've already planted next year's winter wheat crop. Well, it works out then that we could have planted the crop and then get notice from our landlord, completely in keeping with the laws, that our lease is going to be renewed. Well, that's got us in a really awkward spot. So that's one of the things you have to watch out for with periodic tenancies is when is the notice going to be given, and could it happen that notice could be given after we've made some pretty irreversible decisions with respect to that crop. So then when we're talking about a lease, we need to make sure we understand what the lease date is, and does the lease commence on a date that's different from the date we would have access? It might be possible, although somewhat rare, that we have a lease that starts on a date and access to the property isn't available until some later date. Or in some circumstances, We might actually give a tenant access to the property before the lease actually commences. Those are things that need to be explicitly addressed in the lease. And like we talked about earlier, those production cycles for our crops matter. So if we're talking about winter wheat, it sure would be nice if our renewal date occurred during a period where the land might be between production cycles. So we've already harvested wheat grain. It's before we really have to make too many tillage decisions or planning decisions for the next year. And if we do decide that we don't want to renew the lease, then we don't put the landlord and or the tenant in a really difficult situation. Same thing with any other crops or any other sort of production cycles. Let's make sure that if we have a renewing lease, or a terminal lease for that matter, a tenancy for years or a term, excuse me, that we have a lease term that makes sense for the production system that we have in place on that land. A few slides ago, I said that when we give a tenant a lease to property, we're giving them basically all the rights of the landlord, subject to a couple of limits. Number one, we're giving them the access to the land for a limited period of time. So they don't have the land forever. We're giving them a limited period of time in which they can use the land. And also there's a doctrine called waste. And without getting into the legal minutia too much, all we're saying is that the tenant is responsible for taking care of the land so that when they return it to the landlord at the end of the lease, they haven't significantly diminished the value of the land. But other than that, the tenant is given exclusive use of the property unless we specifically limit what they can and can't do in the lease. So one thing we might want to do specifically is talk about production practices. What production practices are prohibited? For example, if we've got land in no-till, it takes some time to get no-till up and running. By most accounts, you're talking about at least a span of 5 years, and in some cases, significantly longer than that. So you might prohibit some tillage activities on the property because you want that no-till system to get established. You may be raising organic crops on a parcel that's right next to the property, so you might want to restrict what kind of herbicides and pesticides can be used on the neighboring parcel. There's been lots of talk about dicamba drift in the news in the past few months. You might be pretty scared about that. You might say, all right, tenant, I don't want you to use any pesticides. That might be subject to drift. All sorts of things might be prohibited in the lease. At the same time, some things may be required. Going back to the no-till system again, we might say, hey, tenant, you're required to use best practices to make sure that our no-till system remains intact and maintains integrity during the period of time that you have this land under lease. You might also restrict what your tenant can do in terms of things like hunting and recreation. You might have it in mind that although you're leasing the land to the tenant, you still want to retain the right to use it for hunting and fishing. Maybe to the exclusion of the tenant, or maybe in conjunction with the tenant. But those are things that you need to think about and incorporate into the lease as well. Lots of times when we've got land, especially when we're talking about land that's being used for livestock, maintenance of fixtures, things like load-out facilities, but especially fencing, become a concern. Each state handles this a little bit differently. Let's talk about it from an Oklahoma perspective. In Oklahoma, our herd law says that the owner of livestock is responsible for keeping the livestock contained. So Oklahoma is a fence-in state. That means that the obligation to maintain fencing is on the livestock owner, and that might be different from the landowner. Well, if you're leasing a pasture, you're the tenant, and your fences are in poor repair, you understand that you're bearing the liability for what might happen if your livestock gets out and injures someone or causes damage to other lands. But at the same time, you might be stuck by a landlord that won't maintain the fences for you. That's one thing you need to work out in that lease. Who's going to be responsible for maintaining fences, and to what standards will they be maintained? Same thing for any other improvements on the property, whether it might be grain handling facilities, like we said, load-out facilities, roads, conservation structures, all that sort of stuff. We need to explicitly address who's going to bear the expense, who's going to incur the labor to actually make sure those things are maintained up to the standards that we need them for on the property. Another important thing to think about is maintenance of soil health. Classic example here is handling soil pH. If we make a lime application or some other pH adjustment to the crop ground on our leased land, that's something that if we do it right should hopefully have advantages for several years. Conversely, if we don't use best practices in our cropping systems, we might be mining nutrients out of the soil. And so what we need to have in our lease is an agreement to say, okay, what are going to be the standards of soil health and soil nutrient balance? Who's going to be responsible for maintaining those things? For example, N, P, and K might often be the responsibility of the tenant, but soil pH and erosion control might be a responsibility of the landlord. Let's talk about how we're going to share those expenses there. How do we calculate rent? And the old days where things were pretty simple. You either had a cash rent or you had a share rent, and everyone knew what those shares were. But just to give you some perspective, we kind of get caught in the regional preferences of where we're at. If I ask people in an Oklahoma audience, you are leasing crop ground on a share rent basis, what should your shares be? And almost always the crowds will say 1/3 and 2/3. If I ask that question in Iowa, the answer is almost always half and half, or in some cases 60-40. And the reason that they're giving me different answers is because the Oklahoma audience often has a winter wheat crop in their head, and the Iowa audience often has a corn crop in their head. And it just makes sense, given the dynamics and the inputs of each of those crops, that it works out often that a 1/3, 2/3 share between landlord and tenant works for wheat, but a 50-50 split might be a lot more appropriate for corn. So the first thing you got to ask yourself about rents is, how do I figure out what rent I should have? Should I have a cash rent or a share rent? And there are lots of considerations that go into that. We probably don't have enough time to explore all of those today. But go to those Lease resources that we talked about that Brent's put there in the chat box for you, and you'll find lots of really good discussion to show you when is a cash rent perhaps more appropriate, when is a share rent more appropriate, and then also give you an outline to think through what really is the appropriate fraction, because it's not always 1/3, 2/3. It's not always half and half. The answer to those questions depend on who's providing what, who's bearing what risk, and who has the relative competencies to provide those inputs. Lots of times today, we also see fixed rents versus variable rents. Variable rents might have floors or ceilings. For example, we might have a cash rent that is stable until our commodity price goes above a certain level, and then we might have a premium added on to our rent. Or it might be constant until our price goes below a certain floor, and then there might be a discount. Variable rents are landlord and tenant's ways of trying to share upside and downside risk. And so a lot of that is driven by the relative bargaining power of the two parties, but it's something that you need to think about. No matter what kind of lease format you have, number one, you need to ask, where is the payment payable? Am I supposed to deliver a check if I'm talking about a cash rent? If I've got a commodity that I'm turning over in terms of a share rent, where am I supposed to deliver that commodity? When am I supposed to deliver that commodity? Or when am I supposed to make that payment? Am I paying in arrears, which means I've incurred one lease period and then I'm paying? Or am I paying in advance, where I pay at the beginning of the lease term? How are the payments supposed to be made? Are they supposed to be made in cash? Are they supposed to be made in commodity? There are just lots of things out there that you need to think through and consider to make sure that both the landlord and the tenant understand how that payment is supposed to be made. And especially when we're talking about variable leases, but also when we're talking about share leases as well, we need to figure out objectively, how are we going to determine the calculations that define our rental payments? If we're talking about a commodity price, is that commodity price based on the nearby futures contract price? On which exchange? For which contract? If we're talking about a local price, which local price do we use? Is it the posted local elevator price on a given day? Is it the local sale barn price? If we're talking about livestock factors. All these things need to be determined so that it's very easy and very clear for both the landlord and the tenant to look at that information and know objectively this is the number on which we're basing our calculations. When we lease land, we might not be the only people that have access or use to the property. We talked about the concept of giving the tenant exclusive use of the property. Well, sometimes landlords forget that. You need to make sure that if there's any other people or parties that have an interest in the land, that's disclosed to the tenant, and that's protection for both the landlord and the tenant. If the land's mortgaged, that's something that we need to know, and our lease probably needs to identify what happens if there's a foreclosure on the property. If there are any mineral interests that the surface owner doesn't own, or if they do own for that matter, we need to understand that, because in Oklahoma, for example, the mineral estate is often dominant over the surface estate, with a few exceptions. And so the mineral estate might begin developing minerals in the property right in the middle of our crop, and we don't have anything we can do about it. Well, that's a pretty significant source of friction between the tenant and the landlord, and that's something that they need to be aware of if it's going to be a possibility. Something that we saw a lot in the early 2010s was landlords giving permission to oil and gas companies to apply drilling mud to land that they had leased to another tenant. That caused a lot of hard feelings, and it was arguably illegal unless the lease actually said something about that, because again, we gave the tenant exclusive use and possession of the property. So if you as a landlord want to reserve the right for you to apply drilling mud to the land, okay, that needs to be explicitly stated in the lease. And oh, by the way, tenant, you should probably make sure that if that's part of your lease, that there's going to be an adjustment made to the amount of rent you have to pay, because that's probably going to knock back the productivity of the land to which the mud's applied for some time. There might be other things out there as well, and probably the classic example of anything else is a wind energy lease, which you kind of see the picture here. That's a bunch of cows enjoying the shade of a turbine on a hot day. It might be that the surface owner leases out the land for wind energy development, and although wind energy development, once it's matured, doesn't take a whole lot of land, during the construction phase, it's a pretty intensive use of that land. And that might severely reduce the value of that leased land to the tenant, so that's something that you need to be prepared for as well, and have adjustment factors in your lease to address. We're going to talk about a partnership agreement here, or I should say actually is a lack of partnership agreement. I want you to think about a share lease for an example. In a share lease, a landlord is working in conjunction with a tenant. The landlord's contributing something towards the inputs, the tenant's contributing something towards the inputs, and they're sharing in the produce of the land. If you were an objective outside observer and you looked at that, you might say, oh, those people are in a partnership. And you might not have ever intended to be in a partnership with your landlord or your tenant. Partnership carries a lot of strings to it. If one of the partners, for example, can't pay a debt, they might be able to go after the partner to seek satisfaction of that debt. And we probably didn't want to do that. That probably wasn't our intention. So in all leases, especially if there's going to be a share lease involved, I strongly encourage people to include a statement that says this is a share lease. We are not a partnership. Underline, bold, italics. I say again, we are not a partnership. And just saying that something's not a partnership doesn't make it show, but it's at least one piece of evidence that you can have to say, hey, we really never intended for this to be a partnership. This is a share lease. People understand that a share lease doesn't constitute a partnership, and we should all just go on our separate ways. Emergency notification and non-emergency notification provisions are also an important part of the lease. You need to have a provision in your lease that says, all right, for legal notices that can be sent by mail or electronic communication, here's how you should reach me. Here's a mailing address that I will check regularly, and I agree that if you send something to this address, I will have received notice of it. But you also need to include emergency notifications, so that if there's a fire, severe weather, any sort of emergency where you need to get a hold of someone quickly, have an emergency contact included in the lease. Hey, Bob, there's a wildfire. You might want to prepare yourself and defend yourself from that. So, okay, that's something that we need to take care of. Those emergency notification procedures, by the way, need to be something that you'll actually have access to on a regular basis. I know frequently we want to make our emergency contact our cell phone, and that is a good idea because we almost always have those on and on us, but if you're at home and your home doesn't get cell phone reception, you might need to include your landline number there as well. How do you handle disagreements? And disagreements are going to arise in leases from time to time. It's just a fact of life. I'm a big fan of including a provision that says, hey, we agree that if there's a disagreement between us and we can't work it out ourselves, we're going to seek mediation first, and then we'll go to litigation maybe. And I like including mediation because mediation is an alternative dispute resolution form where you come up with the solution yourselves. So for example, Oklahoma has an Oklahoma Ag Mediation Service that started out just being a means of mediating disputes between farmers and federal and state agencies, but it has other opportunities there as well. And in mediation, each party tells their story to the mediator, and the mediator works with the parties to facilitate a solution being arrived at by the people themselves. Arbitration is a little bit different. Arbitration is basically like having a private judge, so you don't go completely through the litigation process, but in many ways it's like litigation. And then of course litigation is kind of the be-all end-all solution, but that's kind of tough. Especially you consider the fact that in a small community, once you've sued somebody, oddly, they look at you differently and your relationship's a little bit strained. Mediation, I think, is a good way of going about preserving relationships even though there's been a conflict, and that's why I'm a big fan of it. So I almost pulled off the charge Brett gave me. He gave me 20 minutes to talk about this stuff. I think I've taken 24, which for me is a personal record anyway. We'd like to hear what you have to say about the program today. And know if you have comments, thoughts, or concerns. Brett's posted the link over there in your chat box. The survey's right over there. Click on that. Let us know how we did. But in the meantime, before we close out today, does anyone have any questions? You can pose those over the chat box and let us know, and we'll deal with those. Everyone is stunned and overwhelmed by the amazing amount of information they've been presented. No questions so far. Oh, wait, we have a question coming in. 2 of them. All right, they're pouring in now. Oh, just kidding. Wendy said thanks. Oh, advice for producers on a reverse lease bid. Oh, Donna would come up with a challenging question. Goodness. Donna, that is an excellent question. I haven't had a lot of experience with reverse lease bidding, but let me dig into that and see what I can find for you.
Thank you, Dr. Ferrell. I would like to take this time to remind everyone this is the last webinar this year, but we will continue the Learn at Lunch series again next year, starting on January 16th, and then we'll have a webinar on financial stress testing. So,
thanks everyone for participating today.
Yeah, thank you also for joining us, and we'll see you next time.